Good evening, friends. Today, I'm going to discuss the important judgment on the issue of arrest under the GST Act and under the Custom Act delivered by the Honourable Supreme Court of India in the case of Radhika Agarwal. Though there are a number of other petitions tagged with this petition, and the issue involved in this case is whether the arrests made under the GST Act is valid, whether backed by the law, and the Honourable Supreme Court of India has given their verdict that arrests are valid and upheld the constitutional validity of Section 69. But simultaneously, this judgment is a balanced judgment because it equally safeguards the rights of the dealers, a person to whom the departmental authorities want to arrest. So it is one of the welcome judgment delivered by the Honourable Supreme Court of India on the issue of arrest, on the issue of coercive recoveries made at the time of inspection, search, seizure. So I would like to invite the kind attention towards the judgment of Radhika Agarwal, in which the Honourable Courts has observed that arrest should not be in a routine manner. There must be a valid grounds on the basis of which the departmental authorities want to arrest any person. And Commissioner should apply that there should be reasons to believe on the basis of which the arrest is to be made. It should not be in a haste, in a routine manner. So there must be a valid grounds. There must be a credible material on the basis of which the authorities want to proceed for arrest. And the most important thing which was discussed in this judgment, that is, there must be a valid justification of arrest. If any authority want to proceed for arrest, they must be doubly sure that there is a risk of tampering the evidence or there is a risk of absconding. So if all these things qualifies, then only person can be arrested if he is involved in a serious offence and the evasion of tax is more than 5 crores. So again, I'm saying that it is a balanced judgment, though the validity was upheld, but proper safeguards were discussed in this judgment, which will give good relief to the dealer community. In addition to this, the court has also observed that anticipatory bail is maintainable, meaning thereby if any authority want to arrest any dealer and the dealer has the presumption that he can be arrested, then he can approach the Honourable Court by filing the anticipatory bail, meaning thereby in advance he can get the anticipatory bail, though there is no provision of FIR under the GST Act. So it is equally important that earlier Honourable Supreme Court is of the view that anticipatory bail is not maintainable under this act. But now the Honourable Court has changed their view and has clarified that anticipatory bail is maintainable. So under these circumstances, one can approach the Honourable Court for anticipatory bail. Now the important question arises that the recoveries which were made under coercion, duress at the time of inspection, search, whether those are legal or illegal. Honourable Court has categorically mentioned those are illegal recoveries. Beside voluntarily deposit, every recovery made under duress, coercion is totally illegal. It has no legal backing because there is no provision of advance tax under the GST Act and no amount can be recovered without making the adjudication. And thereafter, 90 days time is to be given to the dealer for depositing the same. Prior to 90 days, no recovery can be made. But we have seen that in number of cases, the departmental authorities at the time of search, seizure, inspection try to get the amount deposited under the head of voluntary deposit. So that is another long subject which is to be discussed, whether those were voluntarily, specifically on the date when the raid was conducted, meaning thereby when the inspection was conducted, or those are under coercion. Needless to say, those were under coercion, because no prudent man will realize on the same day when the authorities were there, and mostly those payments were made in the midnight, early morning, when the authorities were there on the premises. In addition to this, the Honourable Court has also given the view, as earlier there was a judgment of a make my trip under the Service Tax Act. There the Honourable Supreme Court is of the view that the assessment is necessary before arresting. Here they are of the view, the Honourable Judges, Lordships are of the view that even without making the assessment, arrest can be made. So these are the certain observations made by the Honourable Supreme Court, and now the Honourable Supreme Court has fixed the hearing, which will start from 17th of January for final hearing for concluding this matter. So at last I can only say that whatsoever the Honourable Court has observed till today, that is a very balanced judgment given in the favor of dealer, as well as also taken care of the revenue, so that revenue should not hamper and the fundamental rights of the dealer should not hamper. And the most important thing, that the benefit of anticipatory bail was granted to the dealers who are under presumption that arrest can be made. They can approach the Honourable Court and they can easily thereafter show the records to the authorities, and they should not be under pressure of depositing the tax. So I am of the view that this judgment supports the entire business community. Thank you so much for watching this video. Grateful.